are therefore unconstitutional. Likewise, the act of the trial of civilians in the military courts under those provisions is unconstitutional. Excuse me. Ground 3 of the appeal would fail, while the cross appeal succeeds. Grounds 1 and 4, jurisdiction over subject matter. The impugned sections of the UPDF Act under grounds 1 and 4 of the appeal challenge the competence of military courts to try offenses under all enactments. Section 2, now 1, taken together with sections 170 now 179, now 177, and 119, 1G, now 177, 1G, of that act leads to the concurrent jurisdiction of the military and civilian courts in criminal matters. The question here for the consideration is the constitutionality of this provision. In the light of Articles 28 and 44 of the Constitution, which the respondent contends requires trial of criminal offenses in ordinary courts before civil judges. Having found that the courts martial should not generally try civilians, I would narrow the issue at hand thus, open quote, should military officers be tried in the courts martial for all civil offenses in addition to disciplinary offenses? Close. Does their trial in the courts martial for civil offenses contravene Articles 28.1 and 44C of the Constitution? Article 28.1 of the Constitution does not expressly bar trial of military personnel in a specialized military court, which meet the criteria discussed in ground 2. This is because judicial power can properly be given to specialized courts such as the military courts. Does that exception include trial of military personnel for crimes under other enactments? I find the answer to this narrower issue in the determination of the purpose and effect of the impugned provisions. I have already held that the maintenance of discipline is a valid purpose. The effect of the impugned provisions of the Act is that all persons subject to military law will face trial in courts that are markedly different from the ones their civilian counterparts are subjected to for the same offense. In light of the non-derogability of Article 28 of the Constitution and the right to equality under Article 21 of the Constitution, I do not find it justifiable to limit the rights of military personnel as such. I therefore find that the impugned sections 2, 179, 1191A of the UPDF Act adversely affect the liberty interests of all persons subject to military law. Offenses not triable by the courts martial. There are other vital reasons militating against trial of persons subject to military law for all offenses. The court has previously held that there are certain offenses that are not triable by the court martial. This is so where a particular act grants jurisdiction under it only to specific court or only with consent of the DPP. It would therefore be wrong for Parliament to cause a conflict by conferring on courts martial jurisdiction to try such an offense or a similar offense. Where an offense attracts the death penalty, a court martial should have no jurisdiction to try it until a right of appeal is created from sentences for offenses attracting life imprisonment and death penalty to the court's record as is available to the other persons and provided for by the Constitution. The trial of criminal offenses attracting those penalties is unconstitutional for violating Section 28.1, no, Article 28.1, 44C, 21 and 22 of the Constitution. Effect of subordinate court subject matter.